Welcome back to another National Real Estate Exam Prep. And today we're going to talk about the practice of real estate. More specifically, we're going to go over 5 questions with their explanations as to why they are the answer. An apartment rule prohibits pets. A prospective tenant with a physical disability relies on a service animal to assist him. Which of these is true? The landlord may not refuse to rent to a person with a service animal. Under the Fair Housing Act, a service animal is not considered a pet and must be allowed as a reasonable accommodation for individuals with disabilities. A landlord cannot deny housing based on the presence of a service animal and may not charge a pet deposit or pet related fees. This protection ensures equal access to housing for those with documented disabilities. To be classified by the Internal Revenue Service, the IRS, as an independent contractor, a real estate salesperson may receive commissions on transactions as negotiated with the broker. An independent contractor is not entitled to employee benefits like health insurance, paid time off, or a company provided vehicle. For federal tax purposes, they must not be treated as employees. This means they cannot receive a salary or hourly wage. Instead, they are typically paid commissions and are responsible for managing their own taxes and expenses. The act of directing home seekers towards or away from particular areas, either to maintain or to change the character of the neighborhood, is steering. Steering occurs when a real estate professional directs buyers or renters toward or away from certain neighborhoods based on race, religion, ethnicity, or similar factors. This violates Fair Housing Act of 1968, regardless of whether the intent is segregation or integration. Redlining is the unlawful practice by lenders of denying loans or limiting lending in specific areas, often based on the racial or ethnic makeup of the neighborhood. Blockbusting involves encouraging homeowners to sell by suggesting that the presence of a protected class will lower property values, which is also another illegal and discriminatory tactic. The American Disabilities Act, ADA, requires that reasonable accommodations be provided for people with disabilities. The Americans with Disabilities Act, ADA, requires reasonable accommodations for individuals with disabilities in both employment and places of public accommodation, such as rental offices or leasing centers. However, the ADA does not cover all forms of employment discrimination. Those are addressed under separate federal and state laws, such as Civil Rights Act and Equal Employment Opportunity laws. The ADA does not mandate that all real estate be barrier free, but it does require that public facing areas be accessible. In residential settings, the ADA permits landlords to allow tenants to make reasonable modifications at the tenant's expense, provided the changes do not create an undue burden or alter the nature of the housing. A broker, upon reconciling, realized that his office manager had deposited operational funds into the earnest money account. This could be considered commingling. Commingling occurs when a broker mixes client funds, such as earnest money or security deposits, with personal or business funds. This is prohibited as trust funds must be kept in a separate account. If commingling occurs, the broker is responsible for correcting the issue immediately, documenting the violations, and retaining any staff involved, such as property managers. In contrast, conversion or misappropriation involves intentionally using someone else's funds for unauthorized purposes, which is more severe violation and can result in disciplinary action or criminal charges. All right, this was 5 questions with their explanations as to why they are the answer. If this was helpful, give us a thumbs up and subscribe because we drop a new video every week to help you pass your national real estate exam.